Can a WhatsApp chat land you in jail? Can the CCTV footage be relied upon by the court? Can a deleted voice note be resurfaced in a particular case? These are some of the very important questions that we will be dealing today. Hello, everyone, and welcome to Live Law Academy and to this very important session on electronic evidence. In this technology driven world, the electronic evidence has become the centerpiece in criminal cases, in civil disputes, as well as even in election petitions. However, it is not easy to understand it. It is not as simple as clicking the play button on the device or taking a screenshot. However, today we will try to make an attempt to understand this concept in the most simplest way possible. We will be referring to provisions from both Indian Evidence Act and Bharatiya Sakshi Adhiniyam, and we will also see some of the important landmark judgments from this area. But let's begin with something very foundational. India has been one of those few countries who always adapted to the changing world. With the change in technology, with the advancement in science and tech, several amendments have been made to various laws, including Indian Evidence Act, IPC, that is Indian Penal Code, Bankers Books Evidence Act of 1891, RBI Act of 1934. But the biggest game changer was the Information Technology Act of 2000. Through this particular statute, electronic record, the term electronic record was introduced in the legal vocabulary. And the same is reflected in the definition of the word evidence provided under Section 3 of Indian Evidence Act and which has now become Section 2E of Bharatiya Sakshi Adhiniyam. The word evidence is defined to include not only the documentary evidence and the oral evidence, but also electronic record as part of the documentary evidence. It is a part of the documentary evidence. So the effect is the CDs, the drives, the hard drive of the computer, the printout, the voice notes, the digital pictures, audio video recordings, all these can be treated as documents for the purposes of evidence. The next thing that we need to understand is primary versus secondary. These two are the broad categories of evidence, primary and secondary evidences. Primary evidence means the document itself, and secondary evidence means it includes the copies, the photographs, the oral account of the original. Now let's try to connect these primary and secondary evidences to the concept of electronic record. Ask this question. What if the original is stored in a device and printout is taken and a submission is made before the court? It is given in evidence before the court, basically. Will it be a primary evidence or secondary evidence? That is the question. See, the net effect of the definition of evidence. Now there are changes in Bharatiya Sakshi Adhiniyam. Earlier in the definition, though by IT Act, because of the IT Act, Indian Evidence Act was amended, Section 3, it was added that electronic records will be treated as document, but there was no corresponding change in the definition of the document. And now Bharatiya Sakshi Adhiniyam has made that change. Even there is a separate provision now, Section 61. The net effect of all this is that for the purposes of admissibility and effect of admissibility, the electronic record is on the same footing as a normal document. So the rules as to primary and secondary should also be applicable to them, right? So if original is produced before the court, it is primary, just as in the case of document. If something else, not the original record, not the original photograph, not the original video, the copy of it, along with some certificates that will come to later stage during this session, we'll see what is the procedure. If all that is produced, then it will be a secondary evidence. But for secondary evidence, we have separate rules of procedure. There is a separate section altogether dealing with electronic evidence which is secondary in nature. That is Section 65B of Indian Evidence Act, which has now become 63 of Bharatiya Sakshi Adhiniyam. We'll see what is provided. Right? I hope this much is clear to you. Now we can move on to the admissibility. 65A, 65B of Indian Evidence Act, 62 and 63, the corresponding provisions from Bharatiya Sakshi Adhiniyam, BSA. Now, as per Section 65A, Indian Evidence Act, and 62 of the BSA, it is provided that if the electronic evidence is secondary in nature, then the admissibility will be governed by, the procedure will be governed by 65B IEA, Indian Evidence Act, and 63 BSA. I have told this already to you that we have a separate procedure for admissibility of the secondary electronic evidence, right? Now, let's see what are the essentials of this procedure. 65B subsection 2 lays down 4 essentials before the secondary electronic evidence is taken into consideration. It is taken on record. Number 1, the device used must be regularly used during the relevant period. The information must be stored into the same regularly at regular intervals during the course of normal activity. Then the device itself must be in a perfectly functional way during the entire period. And the last requirement is the information reproduced now is the same as the original data which was stored. Right? Apart from this, subsection 4 requires one additional thing, that is a certificate. That certificate has to come from somebody who is in authority, who is either the owner of the data in question, who is either responsible or responsible for its storage and everything, or the management, right? The certificate is required from such a person, and in that certificate it will be mentioned that the 4 requirements of subsection 2 are satisfied in this case. And mind you, if there is no such certification, then the evidence will not be admissible. No certification, you can equate it to no admissibility, right? So these conditions are to be satisfied in case of secondary electronic evidence. Please keep this thing in mind. If the original is produced, then 65B has no role. I will show you how, right? Now, we can move on to the cases, the important cases. And the last one that I'll be discussing is in fact the landmark judgment, which is subsequently cited in every case dealing with electronic evidence. And it is my personal observation and knowledge that, to my knowledge, it is actually that judgment because of which BSA has now made the additions that I have mentioned, which were not there under Indian Evidence Act. Though Section 3 was amended, but still something was missing to complete it. That has been done, but it has been done in the light of this landmark judgment. It is my observation, not read somewhere. It is my own observation. You will also come to the same logical conclusion once I will show you the relevant paragraphs from the judgment in a while. Then the first case is Yusuf Ali versus State of Maharashtra, AIR 1968 Supreme Court 147. In this case, the tape recorded evidence was allowed, but with the caveat that the voice must be clearly identified and the authenticity of such recording must be proved. Then we have the case of N. Sri Rama Reddy versus V.V. Giri, AIR 1971 Supreme Court 1162. In this case, it was held that tape recorded evidence, a tape recorded statement, it can be used to contradict, to corroborate, and to even impeach the impartiality of the witness. Then we have NCT of Delhi versus Navjot Sandhu alias Afsan Guru. This was the parliament attack case. Citation is AIR 2005 Supreme Court 3820. In this case, something interesting happened. The court allowed secondary electronic evidence even in the absence of certificate. I have told you that certificate is mandatory. No certificate is equal to no admissibility. But in this case, the court allowed the electronic evidence even in the absence of such certificate by referring to the general provisions relating to primary and secondary evidences which are applicable to the documents. Though electronic evidence is also a document, we have seen that, right? But for secondary electronic evidence, a special procedure is carved out and these provisions are mandatory. But the court said that even in absence of certificate, which is a mandatory requirement, we can refer to the other provisions relating to primary and secondary documentary evidence and the same can be admissible, right? Then in 2014, Anvar PV versus PK Bashir. This is the landmark judgment that I was talking about. 2014 volume 10 SCC 473. Volume 10 SCC 473. Now I'll share my screen now and I'll show you the relevant paragraphs from this judgment, which will make things much clearer. See, this is para 22 of the judgment. The evidence relating to electronic record, as noted herein before, being a special provision, the general law on secondary evidence, which means the court is talking about secondary electronic evidence, right? Or with respect to secondary electronic evidence, the general law on secondary evidence under 63 read with 65 shall yield to the same, which means shall yield to the 65B. Court is talking about 65B. Then refer to a famous maxim, generalia specialibus non derogant. Special law will always prevail over the general law. It appears the court omitted to take note. Now the court is talking about the Afsan Guru's case, the parliament attack case. It appears the court omitted to take note of section 59 and 65A dealing with admissibility of electronic record. Then 63 and 65 have no application in case of secondary evidence by way of electronic record. In case of secondary evidence by way of electronic record, which provision will govern it? Right? 63 and 65, which are general provisions on secondary evidence as to documents. They are not applicable. The same is wholly governed by 65A and 65B, which are now 62 and 63 respectively under Bharatiya Sakshya Adhiniyam, right? Now, to that extent, the court overruled Navjot Sandhu's case, that is Parliament attack case, it was overruled, right? See, overruled to that extent, right? Then one more relevant part I have highlighted. See, clarification. Important, very important clarification. It is clarified that notwithstanding what we have stated here in the preceding paragraphs on the secondary evidence on electronic record with reference to 59, 65A and 65A that we have just read. Notwithstanding that, what is being said here by the court? See, if an electronic evidence as such is used as primary evidence under section 62, right? 62, primary evidence of documents. Electronic record is also a document. If electronic record is used as a primary evidence under 62, the same is admissible. The same, read from here. The same is admissible. Sorry. The same is admissible in evidence without compliance of the conditions of 65B of the Evidence Act. Now, this clarification makes everything crystal clear that 65B is only meant for secondary electronic evidence. If it is a case of primary electronic evidence, then you can go and make it admissible under the provisions as to primary documentary evidence. No harm in that, right? Then there are some other issues that are to be kept in mind 100% when we approach this area. What if the certificate is missing? This part we have already covered. If the certificate is missing, it is not there, then in case of secondary electronic evidence, it will not be admissible. In case of primary, it will be admissible because 65B is not at all required to be met. Second is effect of deliberate withholding of electronic evidence. Now, in such a case, if something is hidden from the court can draw inference, adverse inference under section 114 of Indian Evidence Act, which is now 119 of Bharatiya Sakshya Adhiniyam, on the presumption that if the thing that is hidden, that is being withheld from the court, the same would have been adverse to the party, right? Would have gone against such party. Then opinion of expert. 45A of Indian Evidence Act and 39 subsection 2 of BSA, according to these provisions, opinion of an expert as to electronic record is a relevant fact. It is one of the relevant facts, right? So to conclude, electronic records like chats, emails, photographs, videos, audio, video recordings, right? These all are recognized as evidence. But in case of secondary electronic evidence, 65B, corresponding provision BSA 63, they have to be mandatorily complied with, otherwise not admissible. In case of primary electronic evidence, it is not at all required, right? Not at all required. Then this reflects the golden mean in Indian approach. We have a blend of modernity and traditional. You know, we are modern enough to recognize the electronic evidence, but we are also traditional enough that we have not let go of the requirement of authenticity and reliability, right? So that's all for today's session. You must master this area of law as well. You simply cannot ignore it. And if you require some more clarifications on it, you can always reach out to us. We'll be more than happy to take your doubts. And if you are somebody who is requiring specialized training while approaching judicial services examination, and even otherwise, if you are somebody who is just wanting that desire is there that to learn from the experts, then you can refer to the description given below and you can explore the courses, and we will be happy to see you in the classes. Until next time, keep on learning And always remember that evidence is very important, and especially when it is digital in nature. Thank you, and I will see you in the next one.